Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We had a couple of docket updates last night in the Justin Baldoni versus Blake Lively legal universe. We went over these documents in full in last night's live stream, but as always, I know some of you cannot sit here and listen to my ADHD rambling for a couple of hours. So I'm here the morning after to give you a quick recap of what we went over last night. First, we had Justin Baldoni and the Wayfarer Party's response to Marvel Studios as Marvel had moved to quash their subpoena seeking documents relating to Nicepool and Baldoni. Second, we went over a document posted by Leanne Newton on Twitter. She was given exclusive permission by Brett McDowell to post his and his partner's formal request to Judge Lyman to preserve any discovery materials relating to Nicepool and Dogpool from the Deadpool and Wolverine movie. And finally, we went over Jennifer Abel's amended answer to Blake Lively's lawsuit, which added some more details in the conspiracy with Stephanie Jones area. In this first letter to the judge, written by Mitchell Schuster, one of the attorneys for Justin and the Wayfarer Parties, they wrote, "Contrary to its representation, Marvel did not meet and confer with us in a good faith effort to resolve this dispute. On April 2nd, Marvel sent the Wayfarer Parties a letter containing its objections to the subpoena, which are the same ones set forth in its recent letter motion. On April 7th, my office met and conferred with Marvel's counsel via telephone about the objections, and although we attempted in good faith to address Marvel's purported concerns about confidentiality and relevancy, Marvel's counsel interrupted us, refusing to engage in that discussion. Instead, Marvel's counsel interjected and stated he merely wanted to know what documents the Wayfarer Parties really needed, regardless of the subpoena's demand for all documents concerning A, the creation, development, modification, or portrayal of Ryan Reynolds' Nicepool character from Deadpool and Wolverine, and B, Justin Baldoni. Marvel's counsel agreed to discuss that limited subset of requested documents with Marvel, and the telephone call ended. However, the next communication the Wayfarer Parties received from Marvel's counsel was an email stating Marvel would be moving to quash the subpoena, and then its subsequent letter motion. As far as the Wayfarer Parties know, Marvel never searched for the narrowed scope of documents or even ascertained whether there are a handful of documents easily accessible to Marvel that can satisfy the subpoena. Marvel's motion should be denied for its failure to meaningfully meet and confer prior to seeking judicial intervention. Even worse, Marvel's motion neglects to advise the court of the Wayfarer Party's proposal to narrow the scope of the subpoena as set forth above. Instead, Marvel inaccurately represents to the court that the Wayfarer Parties are seeking all documents about a character in a major film and all documents concerning an actor. Marvel contends that the documents concerning Nicepool are irrelevant because, according to Marvel, the character is purportedly an expression of an opinion and not one of fact. To begin with, whether Nicepool is an expression of opinion or not is entirely irrelevant to determining the propriety of the Wayfarer Party's subpoena. Even if the Nicepool character were found to be an expression of pure opinion and inactionable in its own right, information concerning Nicepool and communications exchanged in relation thereto would still clearly be relevant to, among other things, the question of Reynolds' alleged malice. Here they're explaining that Ryan Reynolds insisted on the ill-fitting and belated addition of Nicepool to the script while all that conflict was going on the set of It Ends With Us. And in fact, credited it in the film It Ends With Us. Importantly, the information sought could establish malice not only in connection with this portrayal, but also in connection with other defamatory statements Reynolds made at or about the same time over the same events that caused the Wayfarer Parties substantial harm. And Marvel's argument does not apply to the request for information concerning Baldoni. They also note here that whether a character is an expression of opinion or not, a statement of opinion is actionable if implicitly based on undisclosed facts. Marvel does not explain how the subpoena is unduly burdensome, especially given the Wayfarer Party's agreement to narrow the scope. Compliance with the subpoena may moot the need for further discovery concerning Nicepool. Marvel simultaneously contends that the Wayfarer Party should seek Nicepool documents from the parties, and 2, the court should not permit any party to disclose Marvel's documents. As Marvel itself recognizes, this court has entered a protective order that provides for ample protection of any proprietary information. Marvel notes that whether and how unspecified storylines, plots, and characters will appear in upcoming, unreleased projects is the subject of much public interest, and this information is closely guarded by Marvel. However, the subpoena only seeks documents concerning Nicepool from one movie that has already been released, Deadpool and Wolverine. In fact, the character does not appear in any other film in Marvel's franchise and will not appear in any future films since it was killed in its first appearance. Importantly, the case cited by Marvel, purported to establish that movie scripts constitute confidential information, involved scripts for unreleased films, which, in that case, were subject to a preliminary injunction. solely to prevent their improper use by a former employee who had stolen company documents for personal gain. Lastly, Marvel requests in the alternative to the primary relief sought that the court stay discovery from Marvel, pending a determination of Ryan Reynolds' motion to dismiss. However, Reynolds himself has neither sought or obtained a stay of discovery. Additionally, and as detailed in the Wayfair party's opposition to Reynolds' motion, there are not substantial grounds for dismissal of the claims against him. In the unlikely event claims are dismissed with prejudice, the information sought in the subpoenas remains relevant as to the suit against Blake Lively, as the Wayfair parties contend Reynolds was acting as her agent. Marvel will not be prejudiced if the court declines to state compliance with the subpoena because the film has already been released, and any non-public documents can be marked confidential pursuant to the protective order. Next was a document that's yet to formally hit the docket, but posted by Leanne Newton on Twitter. It was submitted by Brett McDowell and his partner Aiko Ishiwata. This was a formal request to the judge to preserve discovery relating to Nicepool and Dogpool from the movie. Now, like I said, it hasn't yet formally hit the docket, but you can read more on Leanne, who's going to be doing a breakdown of this. And she also just started a YouTube channel. So what I want to do is I'm going to link to her YouTube channel in the description of this video. And I would recommend you subscribe to her because she's going to be able to explain this a lot better than I am. In fact, I ask her a lot of questions when I don't understand things. She's very informative and her accent is delightful. So go give her a follow and she's going to explain all that for us in greater detail because when I was reading through it, I noticed there were a lot of terms that I don't necessarily understand. However, I wanted to go over that again just to make sure you guys know where to find it. I'm also going to link to Brett and Aiko's Twitter accounts in the description of this video so you know where to find them and read more about their story as well. Finally, we have the amended answer to Blake Lively's complaint filed by Jennifer Abel, and this was filed just on behalf of Jennifer Abel. None of the other Wayfair parties have amended their responses to Blake yet. I don't know if they're going to do that or not, but all the newer and more interesting stuff is at the bottom of the document here. So in addition to the first and second causes of action in this document, they have added a third cause of action, contribution. And this is part of the document where Abel's explaining why Jones' work should have to give compensation for what she's possibly going to be found liable for, and her attorney's fees. Although plaintiff Blake Lively made the choice not to name Jones' works as a defendant, this choice was the result of unlawful and unethical collusion between Lively and Jones' works, acting by and through Jones. Because of Jones' works' collusion with plaintiff against both Abel and Jones' works' former clients and Jones' own negligent handling of public relations duties, to the extent Abel is found culpable for any injury which plaintiff may be found to have suffered, Jones' works is jointly responsible and a concurrent wrongdoer. Jones' works' acts or omissions had a part in causing or augmenting any injury which plaintiffs may be found to have suffered, and indeed played a greater part relative to Abel's acts or omissions. Accordingly, Jones' works owes Abel contribution for the portion of the damages awarded against Abel attributable to Jones' works' own negligence. And they were explaining this a little more starting in paragraph 37. In addition, Jones personally interfered with Abel's competent handling of her duties, including by attempting to insert herself with poorly timed negative communications to the press and public that were discovered by plaintiff's own publicist Leslie Sloan. Jones' blunders clumsily disrupted a putative truce with Sloan by communicating negatively with the media about plaintiff, Blake Lively, exacerbating negative press and public attention on plaintiff by adding fuel to negative stories of a feud with plaintiff. Jones' incompetent handling of communications with the press only caused negative stories to circulate further and attract greater attention. Abel was named as a defendant in plaintiff's pleadings only because of and in direct consequence of Abel's discharge of her duties as a competent PR professional employed by Jones' works. Upon information and belief, Jones' works was not named as a defendant in plaintiff's lawsuit because Jones and Jones' works conspired with plaintiff to exploit Abel's private communications that Jones and Jones' works stole and unlawfully intercepted for the purpose of harming Jones' works' former clients, Wayfair, Heath, and Baldoni. All right, guys, that's about the size of it for everything that came out last night. I'll be keeping an eye out for more news, and I'll see you all soon.